You are watching a master at work.
You know, they say there's no money.
You are watching
They say that HJR 192 does not exist.
You are
They
watching
say that the United States did not file bankruptcy in 1933.
You are watching a master at work.
They say that they are not treating us like corporations when we walk into court. They say that our names are not titles. They say that we cannot
You are watching
be
a
more
master at
than
work.
a servant. They say that they are not fiduciaries, they are not trustees, but yet they say a lot of stuff.
You are watching a master at work.
But when we look into it and we do the
You are
research,
watching a master
we
at work.
find out that they are everything they say they're not. So what are we gonna do about it? Are we gonna let them continue to say what they say, or are we gonna stand up and start speaking for ourselves? You cannot speak up for yourself if you remain silent. You cannot speak up for yourself if you refuse to speak. You cannot speak up for yourself if you are a fiction. Are you a fiction? Are you a fiction? Are you a fiction? Only time will tell.
Ladies and gentlemen, gentlemen and ladies, ladies and gents, this will be the third video done in less than 6 hours. We got some information we're going to talk to you about, and we're going to let Baby, Baby, Don't Cry play in the background. Alright, shall we? We are doing a document right now. Let's bring our screen up for a second. I was reading this document and I was somewhat amazed. Oh, we have two, this one is saying, oh, I see why, because I'm using the other program, but let's see if we can still get it to pull up. I would like to show you this, but yes, there's a problem, so I'm gonna have to pause y'all, and you're gonna miss Baby Baby Don't Cry, because I'm gonna let the music keep playing, but then I'll show you what I'm talking about in just a second. Ah, see, you didn't miss it after all. Okay, ladies and gentlemen, we have the mARTeN'S clause. You heard of mARTeN'S clause? I've heard of Santa Claus, but there is a Martin clause. It's his brother, you know, his brother from another mother, the one who's the drunk and, you know, doesn't show up at all of the events except for that he's drunk, and the one that throws up on everybody at the party. That's Martin. So, Martin clause. He talks about the principles of humanity and the dictates of public consciousness. So let's find out what's going on with Martin and his clauses. Un momento, ladies and gentlemen. Alright, together with the principles, you know what? I'm sorry, ladies and gentlemen, but there are certain songs that I've heard way too much in my life. And that's one of them. Yeah, we can skip you too. Nope. 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 There you go. We're going to break it down just a little bit more simpler. Alright, together with the principles prohibiting weapons in the nature that cause superfluous injury and or calculate the cause of unnecessary suffering, the Martin Clause in the preamble of the Hague Convention on the Laws and Customs of War on Land is an enduring legacy of those instruments. In the years since the formulation, the Martin Clause has been relied upon in the Nuremberg trials jurisprudence, addressed by the International Court of Justice and Human Rights bodies, and reiterated in many humanitarian law treaties that regulate the means and methods of warfare. It was restated in 1949 at the Geneva Convention for the Protection of Victims of War. Protections of Victims of War. In 1977, additional protocols of those conventions and the preamble to the convention on the prohibitions and restrictions of the use of certain conventional weapons, albeit in slightly different versions. The Martin Clause was paraphrased in the Resolution 23 of the Tehran, Iran Conference of Human Rights in 1968 and cited or otherwise referenced in the several national military manuals, including those of the United States, United Kingdom, and Germany. Moreover, attempts have been, gotta skip all of this, you can get that when you download the document, the Hague Peace Conference. It's a symposium. Oh, what's the document called? I showed you at the top. Okay. Certainly been made, including the parties before the International Court of Justice to invoke the clause in the absence of specific norms of customary and conventional laws to outlaw the use of nuclear weapons. To outlaw the use of nuclear weapons? No. Sorry, the United States uses nuclear weapons every single time they drop a smart bomb. They call them smart bombs, but these weapons are laced with nuclear material. Why do you think the burns are so severe? Why do you think the damage is so massive when they drop a bomb? They call them bunker busters. Okay, what accounts for the continuing currency of this provision? After all, the Martin Clause originated as supplementary and residual protections based on the sources of morality and of law, pending on the comprehensive codification of the law of wars. See, they codified everything. So let's do the Martin Clause, the origin of the clause. Notice this, formulated in 1899, the Martin Clause read, "Until a more complete code of the laws of war is issued, the high contracting parties," high contracting, who's contracting with each other? The high ones, the ones who are smoking that stuff. The high contracting parties think it right. See, they were high when they wrote this. Think it right to declare that in cases not included in the regulations adopted by them, the populations and the belligerents, who the belligerents? I ain't no belligerent. Remain under the protection and the empire of principles of international law as a result from the uses established between civilized nations, from the laws of humanity and the requirements of the public conscience. Ladies and gentlemen, I guarantee you, this is where our foundation is with the laws of humanity. You don't believe me? They just told you. What did they say? Well, let's go there and take a look again. It says that the populations, the belligerents are those individuals who are enemies of war, those who are ignorant, stupid, and don't want to follow the protocols. It says, remain under the protection of the empire and the principles of international law. So we should be bringing our documents and ourselves under the principles of the laws of humanity and international law as a result from the usage established between civilized nations, from the laws of humanity and the requirements of public consciousness. Now it says the 1907 version was somewhat different. Inhabitants was replaced by populations. To older terms, laws of nations was substituted for international law. You know what? Then we should be using not international law, but the law of nations. And requirements gave way to dictates, and we should go to requirements. Although the 1899 version and the 1907 version speaks of the laws of humanity, it has become common practice, which I shall follow, to refer to them as the principles of humanity. I don't follow practice. We're going to stick with the laws of humanity. Okay? Now, I don't have time to read this whole document now. I just wanted to let you know that the laws of humanity, I just read it in a case with the Supreme Court when I did the video on legal tender, as it have an equal value. The Supreme Court refers to Hall's International Law Dictionary, and he in that dictionary refers to international law and the laws of humanity, and he says that all laws are based on the principles of the laws of humanity. Well, what is the laws of humanity? Well, you're going to have to read on. Now, this gentleman here is definitely a lawyer, because notice what he says. He says that where the terms come from, what they gave way to, and he says, although both of these speak of the laws of humanity, it has become common practice, which I shall follow. Sorry, people. Just because somebody is sitting up there lighting a match and setting themselves on fire doesn't mean all of you have to sit up there and light a match and set yourselves on fire. This is not that type of party where we follow the leader. You don't do something because somebody else is doing it. Not without good reason, and he does not give good reason. Let's go a little bit further. Martin uses several names over his lifetime. Oh, look at that. They say Martin had aliases. Martin had aliases? Okay. Let's see. The weapons of land. Nope, that's not what I'm looking for. Let's see.
1, 2, here we go. 1, 2.
The modernization of the clause. The Geneva Convention employs a version of the Martin Clause in their denunciation clause. Denunciation clause! For a somewhat different but parallel goal to make clear that if they denounce the convention, the parties will remain bound by the principles of the law of nations. Remember I told you, pay attention. They said they changed it from the law of nations to international law. I suggest will be using the law of nations because it precedes the so-called use of the term international law, as they result from the uses of established among civilized people the laws of humanity and the dictates of public conscience. This is what we should be utilizing. Sorry, it won't let me. I'm still waiting for this to finish, and conversion failed. That's what it's been saying that the whole time. Let's see if we can try converting it again. There shouldn't be no failing of the conversion, because this is I was wondering why it was taking so long. This is a pretty short document. It's only 13 pages, and so the conversion should have been simple. So I'm going to have to use Adobe to convert it, and then go with my solid PDF and convert it, because there's probably something wrong with the download of the document. Oh, the Redress Right organization changed it like I told you I would. Okay, and again, we want to thank all 382,318 of you from visiting us. And those of you who visit us more than once, twice, 15, 100 times, thank you. We appreciate it. Now, we're going to get back to this video. I opened up the wrong one. Let's get back to here. This is the point, people. We want to use the Corey I video will be up soon, but I promised Corey that I would let him review the video before I put it up there for you all. Okay, it is marked as private, so you will not get the option of viewing the video until Corey has approved for its being placed up there. But you'll see in the conversation that he speaks of us not using the phrases and the laws of today. Okay, that we should be using the phrases and the laws of yesterday. Now, notice what it says. This provision thus guarantees that international customary law will still apply for states no longer bound by the Geneva Convention and its treaties. I'm promising you, this is where we should be going. Why? Because the United States has ignored the Geneva Convention. However, they cannot ignore international customary laws or the law of nations, the principles on which those laws were put together. Of course, the status of the Geneva Convention as customary law has been confirmed by the International Court of Justice and is hardly ever contested. Excuse me? The Geneva Convention customary laws have been confirmed. Okay, customary laws, it's the Martin Clause. Remember, they say we're enemy combatants. They say that we are at war with them. That's why our Declaration of Executorship speaks of us as being peaceful inhabitants. Non-aggressive, non-belligerence is the phrase that we're going to be adding. Okay? And we're going to be adding many of the phrases from this document. Why? Looking at this right here. 15. Law reports of trials of war criminals. It caught my attention for some reason. The protections and authority of the principles of the international law or the law of nations derive from established customs. Common law, interesting. From the principles of humanity and the dictates of public consciousness. Do you notice how they keep saying the same thing? Let's go down, because we're going to let all of you go over this document. And how did I stumble upon this? Like I said, I followed the Supreme Court. They mentioned something, and I went from there. Protocol 1. Okay? That's where that's coming from. Let's see if we can go down and see if there's anything. The Clause and General Principles. American Journal of International Law. The principles of humanity are not different from the elementary consideration of humanity, a concept to which judges, arbitrators, rapporteurs, I don't know that word, so sorry, I'm not going to sit up here, I'm too tired to be sitting up here looking at it, trying to figure it out. I probably have heard it pronounced before, but not going to do it. And others have long attempted to give specific meaning to the laws and principles of humanity. It has been applied in particular to organizations of states, the United States. I'm not going to deal with that Channel case. The International Court of Justice observed that Albania organizations were based not on the Hague Convention of 1907, number 8, which is applicable in times of war, but on certain general and well-organized principles, namely elementary consideration of humanity, even more exacting in peace than war. Earlier, the arbitral tribunal, in the, not even going to sit up there and pronounce that name, case in 1928, case applied the principles of humanity to limit the scope of permissible reprisal. Okay, in the merit phrase, military and paramilitary activities in and against Nicaragua, the International Court of Justice, interesting, considered that the conduct of the United States may be judged according to the fundamental general principles of humanitarian law. Fundamental general principles of humanitarian law. And you notice it's in quotations. Do you know what, ladies and gentlemen? Didn't they just give us what we needed? We tell the courts that the United States is bound to the fundamental general principles of humanitarian law, or the laws of humanity, and the law of nations, constitutes a minimum yardstick in addition to a more elaborate rules, which are also applied in international conflicts, and they are rules which the court's opinion is reflected in the court in 1949, called the Elementary Considerations of Humanity. This statement of the court was invoked in the UN Secretary General in his report on the statutes of international criminal tribunals for the former Yugoslavian president Borsevic. Okay. Anyway, ladies and gentlemen, basically we're letting you know that we know that the courts are under international law or the law of nations, and we also know, oh, I love this, and we're going to cover this and then we're going to conclude this video. The clause cited by the British Manual of Military Law, together with the principles of chivalry, whatever it is. See, told you I'm too tired. As an argument for establishing the parameters of the kind and the degree of violence that may be used by a belligerent. Do you understand that was a word that the individual who wrote the International Law Dictionary, that was a word that he used often, belligerent. So I would look up the legal definition because the courts call individuals belligerent. You don't believe me? Go ahead and look up the legal definition for belligerent. Okay, so let's make sure we get on track here. The courts have been under international law since the 1940s. Okay, all the judges are in international law. That's why their oaths don't apply, because they're not operating as judges. They took an oath as a judge, but not an oath as a corporate official. Their first duty, according to law, is to the administration, the corporation. So we go in there under the laws of humanity. And we remind the court that under international law, it is bound to the laws of humanity, that I am not a belligerent until this court proves beyond a shadow of a doubt that I am. And then I will bring charges against the court for fraud, for defamation. Just that simple. That's me. That's what I do. Okay, ladies and gentlemen, we're just putting you on a course. We can't give you all the details. Oh, this is my song. Y'all know this is my song. This is the Spinners, and it takes a fool to build a nation. Okay, so we want to thank you. Before the words come on, ladies and gentlemen, we say it has been a pleasure bringing this information to you, and we're sorry that it's so quick. We just pulled up the document just prior to uploading the other video, which is going to take about another 40 minutes, but nonetheless, it's 72 minutes.
At redressright.org. That's again, y'all. redressright.org.
Ladies and gentlemen, yeah!